Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Well, we waited 2.5 months. They needed not one, but two continuances, but the state of Maryland has finally responded to the United States Supreme Court in the matter of Snope v. Brown. We're going to go through some of their response. You know, when they asked for all those extra continuances, one might have thought they were playing games, but I was trying to give them the benefit of the doubt, thinking that they were going to deliver just one doozy of a memorandum, something that would be just so brilliant, we'd like, hadn't thought of that before. Well, that's not what happened. No, instead, it's the same old, same old. We'll go through some of it today, but you've heard it all before. So today, let's spend a few minutes and let's talk about why Maryland thinks its assault weapon ban is just fine. Okay, hey, before we get going too far down the road, we're going down. Let's remember that this video is being brought to us by the Sonoran Desert Institute. That's right, arm yourself with education today. Launch your career in the firearms industry today. And most importantly, defend the inalienable rights of millions of Americans nationwide, all through education. They have a program for just about anything that you may need or desire. For more information, either check them out down there in the description box or visit them at sdi.edu. Okay, America, we have been waiting on bated breath because we were hoping that the state of Maryland was going to finally get around to responding to the petition and multiple amicus briefs in support of it in the matter of Snope v. Brown. Now, I'm getting pretty used to seeing the same old, and you're probably getting pretty used to hearing the same old, and there is a lot of that here. But the credence and credit that the state of Maryland gives to the Fourth Circuit for its in-depth analysis and strong constitutional analytical skills really is kind of nauseating, because this actually comes from their memorandum. Having articulated the governing standards, the Fourth Circuit examined Maryland's assault weapons prohibitions. It first looked to whether the plain text of the Second Amendment encompassed the right to possess the types of weapons covered by Maryland's law. Citing Heller, the Fourth Circuit noted that by codifying the pre-existing right to keep and bear arms, the Second Amendment had memorialized a specific entitlement with a particular meaning in the ratifying public's consciousness with baked-in prerogatives and qualifications alike. What? They said what? That's right. And then they also said, and because the text of the Second Amendment, like the text of other constitutional provisions, must be interpreted against its historical and legal backdrop, the court recognized that its role under Bruin's first step was to assess the historical scope of the right to keep and bear arms to determine whether the text of the Second Amendment encompasses the right to possess the assault weapons at issue. Wrong. That is absolutely wrong. The test is very simple. Does the text of the Second Amendment cover the activity? When we're talking about possessing firearms, the answer is yes. Then we go to part two, and then we start injecting history into the equation. On that score, the Fourth Circuit looked to Heller's statement that the central component of the individual right codified by the Second Amendment was self-defense. That's right. Because then the Fourth Circuit said, well, listen, if we have limits on what kind of force you can use in self-defense and when you can use force in self-defense, why wouldn't that equate to limits on the Second Amendment? That is actually their ruling. And of course, the state of Maryland thinks that is perfectly okay. Thus, the Fourth Circuit continued, just as the right to self-defense had limitations at the time of the founding, so too did the right to keep and bear arms that enabled it. The Fourth Circuit then explained how these principles apply to questions of what arms may be kept and carried. That's right. That's the ruling that they are trying to defend. And then they go on in more nauseating fashion to state, but recalling Heller's reference to the common law restriction on dangerous and unusual weapons, the court observed that excessively dangerous arms were not reasonably related or proportional to the end of self-defense, but were rather better suited for offensive criminal or military purposes and were thus understood to fall outside the reach of the right. That's right. That is the interest balancing test that they want to inject. And it's even more nauseating because now the court wants to become self-defense and firearms experts. Then, of course, Maryland goes through all the potential horror stories that you can possibly use, leaving out as much detail as humanly possible just to make it look like these AR-15s are essentially running around and shooting up places all by themselves. Again, stating that that's a reason for their ban, again, injecting interest balancing back into it. But then they also want to point out, by contrast, the court reason, the plaintiffs had not shown that the AR-15 was suitable for self-defense. That's right. That apparently there is some type of burden that shifts upon us to show that the firearms are suitable for self-defense, and suitable in whose mind? Because if it's suitable in your mind, that's not good enough. It has to be suitable in the court's mind. Then we get to the common use test, which should be perhaps the most easiest equation there is, right? It's a numerical value test. Now we can debate on what that threshold number is, but that's all the test is a numerical value. Well, unless of course you're the state of Maryland. The Fourth Circuit identified a series of flaws in this ill-conceived popularity test. For example, the plaintiff's argument was inconsistent with Bruin's suggestion that to fall within the Second Amendment, a weapon must be in common use today for self-defense, which is not what Bruin said. And then, of course, they point out, in addition, there was no clear threshold for the number of firearms that would allow a court to proclaim that a certain weapon was in common use. Okay, let's just say there's not a certain threshold. And let's say that the numbers in Katana, 200,000 stun guns, is way too low. Okay, let's multiply that by 5. All right, hey, 5 times as much. That's 1 million. Do we honestly believe that there's more than 1 million semi-automatic rifles, or what some states call assault weapons, in circulation today? Heck, there's more than 1 million in states alone in the United States right now. But then, of course, the state of Maryland wants to say, hey, listen, so even though the court found that the Second Amendment doesn't apply, they did bother to go ahead and do the historical analysis test. So apparently they believe that there's a historical analysis in both parts of the test. Again, it doesn't make any sense. But then, of course, they went through the usual suspects. You know, the Bowie knives, gunpowder storage, TNT storage, the going arms laws, and things like that. All of which, of course, justify the outright ban of a platform of firearm that is otherwise in common use for lawful purposes. But I do want you to know that the state of Maryland is perfectly okay using the numerical value to prove that something is not protected by the Second Amendment. Don't believe me? This is a quote from their memorandum. Instead, as the Fourth Circuit observed, to the extent a common use inquiry might be relevant, it is to determine which weapons fall outside the ambit of the Second Amendment. Now, one of the big reasons that they're saying, hey, Supreme Court, there's no reason for you to take review of this is because there's no circuit split. Let me explain to you why there is no circuit split. Let me explain to you why the Fifth Circuit has never had to rule that assault weapon bans are unconstitutional. It's a very simple fact that no state inside the Fifth Circuit's dumb enough to actually pass a law by that. So at some point, you're going to end up with the Fourth, the Seventh, and the Ninth Circuit saying, hey, it's perfectly okay, and none of the other circuits are ever going to reach a ruling on it simply because no state is going to even try to pass legislation like that within the circuit. And if you really want to understand the disdain that the state of Maryland has, not only for lawful and responsible gun owners inside their state, but for the concept of the common use test, let me point out to you that they had the audacity to plead in their memorandum. Moreover, as the Fourth Circuit observed, petitioners' proposed common use test would lead to absurd consequences and would undermine democratic self-governance. The ultimate form of democratic self-governance is, in fact, the Constitution. It's what prevents government from infringing upon democratic self-governance. The state of Maryland is actually complaining in their memorandum that this would allow the Constitution to function as it was designed to function. Of course, the rest of the argument is, hey, this just needs more time to percolate. This issue's fairly new. It hasn't really been analyzed much under Bruin. And they would love nothing more than that for multiple reasons. Number one, it would delay the agony for any citizen who's living under the purview of one of these laws. But number two, at some point, yeah, we will have rulings out of the Fourth and the Seventh and the Ninth Circuit, and they will all be like, it's all honky-dory. And then their arguments, of course, are going to be, hey, there is no circuit split and everyone else has upheld it. So why on God's green earth would you accept review? Okay, the case once again is Snope v. Brown. We're going to have to very carefully watch this case. This is big. You want to resolve the assault weapon ban issue once and for all? It's this case right here, Snope v. Brown. So we are going to be paying very careful attention to it. We'll link up the state of Maryland's memorandum below so you can geek out on it for yourself. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there. You let us know. If you just want to subscribe to our monthly newsletter, the ability to do all of that is right down there in the description box. And then finally, and most importantly, let's remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.